hearing in the appeal of Chen against Chen.
Mr. MacDonald.
As you know, I appear for the appellant with my learned friend Mr. DeFern and my learned friend Mr. Parker and Ms. Lord appear for the respondent.
Yes, indeed.
Lords, our task today, the substantive issues, as we see it, is to satisfy your lordships that Mr. Justice Bannister was right and the Court of Appeal were wrong. Before I go any further on this, I ought to ask your lordships whether your lordships would prefer me to start with the substantive issues or the jurisdiction issues.
The substantive issues.
Much obliged. Lords, I defined my task in the way I did just now, which may have appeared a statement of the obvious, because it occurred to me, looking at our case, that we focused very heavily on trying to demonstrate that the Court of Appeal were wrong, but we've rather neglected Mr. Justice Bannister, and so I'd like to start by demonstrating why he was right. My lords, if your lordships would turn to the
yes, is it being said he was wrong if he was entitled? As I understand, the argument is not that he was, as it were, wrong. It's that he wasn't entitled to reach the conclusion that he did.
Yes.
So
see,
that's really the issue, isn't it?
Well, I've tried to deal with that in the submissions of the appeal.
Yes.
Because that, of course, was their conclusion.
But if you want to take us briefly to this, yes, but...
I beg your pardon, Lord?
If you want to take us briefly to that, yes. But as I understand it, the real issue is, was or was the judge not entitled, as it were, to fall back on the document, say it was genuine and give effect to it, given that it was neither party's case, that was the position?
Yes.
That's really the issue on the substantive case.
I think there's also is not a suggestion that Mr. Justice Bannister was not entitled to reject Mr. Nung's explanation.
Yes.
So that's a factual issue, and I suppose if that was right, then one wouldn't get to the question whether the judge was entitled.
Yeah, that's true.
I'm going to come on to that, and my plan was to come on to that later in the morning and take your lordships to the transcript of the relevant part of Mr. Um's cross-examination, which in my submission shows that it was put to him entirely fairly and thoroughly.
But you're going to do that for the purpose of showing that his evidence was approached in a procedurally correct fashion.
Exactly.
Rather than trying to persuade us that the judge was right to reject it.
Well, if it was...
It's hard for us to say whether he should have rejected it or not at 2 stages removed.
Quite. As far as the question my Lord Newmarket just put to me is concerned, I should say straight away, because it's not in our case, that in the course of reviewing my learned friend's submissions, we have come across what we regard as a highly material decision of this board in the case of Prime Site and Lavarello. Lord Newberger was in that, but I don't believe...
It was appeal from Gibraltar, wasn't it?
Exactly. I don't believe any of the rest of your lordships were. Although it has been referred to in a couple of cases since, it may be new to some of your lordships. So let me show your lordships...
What are you citing? What proposition are you citing it for?
I cite it for the proposition that if the parties have entered into documents expressing a transaction, a contractual transaction, which state that a consideration has been agreed and paid, even though they both know that that is not the case. Each of them is stopped from relying in any subsequent dispute, or if that's the right way, a helpful way to put it, on the fact that the consideration wasn't paid. And in Prime Site and Lavarello, the facts were actually strikingly similar to the facts of this case. Now, your lordships will find it in volume 24 of the authorities. It's the first, volume 24 is the bundle of additional authorities which are not referred to in either side's cases, and a couple of authorities which had been omitted by oversight earlier. And Prime Site and Lavarello starts at page 4838 of the electronic bundle, tab 1 of volume 24.
Right.
If your lordships go to page 4843, your lordships will find the material facts explained. Paragraph 6, Mr. Maraki...
It's a factual statement that the consideration had actually been paid, isn't it?
Yes. Yeah, before we leave the first page, the headnote is entirely accurate and comprehensive statement of the principles on which we rely for the purpose of this case. If I can just read that held one, that in accordance with the principle of party autonomy, which underlay the common law of contract, where parties knowing the facts to the full were shown to have entered into a transaction by assuming a different state of facts or law as between themselves for the purpose of that transaction, a convention would be established under which the parties would be estopped from denying or challenging the assumed state of facts or law. That declaratory statements in a deed, and this was a case of a deed, as your lordships will see, the board stated that the principles which applied were not confined to deeds, but applied it to any contract. Declaratory statements in a deed which were intended to be contractually binding agreement to treat something as if it were true even though the parties knew it was not, and which were not vitiated by factors such as illegality or misrepresentation, were as effective for that purpose as any other express or implied contractual convention, and that while contractual estoppels were subject to the same limits under the general law of contract as other contractual provisions, there was nothing inherently contrary to public policy in parties agreeing to contract on the basis that certain facts were to be treated as established for the purposes of their transaction, although they knew the facts to be otherwise. Now, in this case, as your lordships will see, the fact was the payment of consideration, just in a nutshell, but I still wish to show your lordships the facts in detail. In a nutshell, Mr. and Mrs. Maraki arranged for an apartment of which Mr. Maraki was the legal owner, to be transferred to a company acquired by Mrs. Maraki for a substantial consideration which was expressed in the assignment as having been paid, even though they both knew that it was not paid and was never intended to be paid. Mr. Maraki later became bankrupt, and his trustee in bankruptcy ascertained that the price stated in the assignment to the company had never been paid, and demanded the money in question from the company on Mr. Meraki's behalf. And he was defeated by the proposition in paragraph 1. I should comment, again, before we go to the facts in detail, that it's fairly obvious, though it doesn't say so, that the reason why the trustee hadn't taken what perhaps would be the more obvious alternative of demanding the real property back, or demanding the underlease back, was that the underlease had been charged by the company to secure Mr. Meraki's debts to third parties, and therefore the underlease was probably itself valueless. And so the trustees, the only practical course open to the trustee was to demand the belated payment of the consideration stated in the assignment. If your lordships would go down to page 4843 and look at paragraph 6. Rather.
So if you put in your contract, the consideration is £499,000, but I undertake never to demand its payment, then there's no consideration. But if you put in your contract, the consideration is £499,000, which is now conclusively treated as paid, then you're stopped.
In that rather different situation, I'm prepared to accept for the sake of argument at this stage that that would be correct, my lord, but if I've fallen into a trap, I'll try to get out of it later.
I just wondered how it worked.
The paragraph 5 on page 4843 or chronologically, we start perhaps with paragraph 6 first. There was an underlease of an apartment in Gibraltar which had been acquired by Mr. Meraki in 1995. And 12 years later, para 5, Mr. Meraki, a company is formed with 1,000 shares, and Mrs. Meraki is the beneficial owner of 999, and the remaining share is held in trust for Mr. Meraki, who, according to Mrs. Meraki, held that as well in trust for herself. Yes. And Mr. Meraki assigned it to the company.
Which is basically her.
Sorry, my lord?
Which is basically Mrs. Meraki, yes.
Yes. Yeah. Paragraph 7, the assignment recited that Mr. Meraki had agreed to sell, and the assignee, the company, had agreed to purchase the premises for £499,950. And clause 1 said, in consideration of the sum of £499,950, now paid by...
receipt and payment is acknowledged, yep.
Sorry, my lord?
Receipt and payment is acknowledged, yep.
Yeah, that's right.
Okay, we got that. And there's the assignment.
Exactly like the transfer of the shares in this case, which acknowledged the...
And it's common ground that no payment was in fact made.
That's right. And then paragraphs 10 to 13, Mr. Meraki becomes bankrupt. Paragraph 11, official trustee demands the money from Mrs. Meraki as sole director of the company. And the official trustee presents a statutory demand and a winding up petition. And then 14, and this is an interesting reminiscence of the present case. Charles Gomez, who were Mrs. Meraki's solicitors, write to the official trustee setting out different grounds. They say Mrs. Meraki had been the beneficial owner all the time. So that's an analogy to Madame Chen's failed case on the so-called 1996 oral agreement. But that claim was on the table, but hadn't yet been resolved.
Yeah.
And it wasn't, it was rejected as being a basis on which the demand on behalf of Mr. Meraki to the company could be resisted.
Yeah.
Now, the question for the board on those facts is formulated by Lord Toulson in paragraph 1, starting at 4842. If a written agreement contains an acknowledgement of a fact which both parties at the time of the agreement know to be untrue, does the law enable one of them to rely on that acknowledgement so as to estop the other from controverting the agreed statement in an action brought on the agreement? This question, then the question arises on the appeal in connection with the winding up petition. And then, having dealt with the facts, if we go to paragraph 30, (4847),
Yes.
probably convenient to start at 29. Doctrine of estoppel by deed overlaps with the doctrines of estoppel by representation, estoppel by convention. Estoppel by representation is inducement to enter into transaction of faith of a statement to make it unfair the representor should go back on it. Estoppel by convention is express or implied agreement that a certain state of facts is to be treated as true and unfair for one or other to resile from the basis on which the transaction had proceeded. But anticipating where the reasoning is going, it's made clear in the board's reasoning in this case that unfairness is nothing to do with the enforcement of the estoppel which prevented Mr. Meraki's trustee from saying that the consideration had not been paid.
Was it held that reliance was unnecessary?
Contract.
Was it held that reliance was unnecessary for estoppel of this?
Yes.
Right.
Yes.
I see.
Yeah. And hence, in the very latest edition of Spencer Bauer, the 2017 edition of Spencer Bauer, which is now called, the one that used to be called Spencer Bauer estoppel by misrepresentation, or by representation, it's now being called Spencer Bauer on reliance-based estoppel, and the editor's scheme is to comprehend everything within that category.
But this is not reliance-based.
No, and they have difficulty in fitting this in.
Yes.
You say it's a contractual bar rather than a bar created by detrimental reliance.
Exactly.
Yes.
And
Yes, it's a contractual bar, but it does amount to using estoppel as a sword rather than simply as a shield, doesn't it?
well, Chitty, in their paragraph on this line of authority, make that point, and they say that the label of estoppel is misleading for this.
Really a contractual warranty.
Yes, that's how it's put
Of
sometimes.
facts as to which it's irrelevant what the parties knew. They've simply contracted to treat those facts as correct, even if not.
It's been labelled contractual estoppel in the Court of Appeal in the two cases which we've included following this one in Bundle 24. One Moorbeek LJ, the other Akins LJ, as part of the ratio. Yes. And it's called contractual estoppel in the principal article, which has, so far as I know, been published on the subject so far, which is in 2016 LQR.
Yeah, we got that in the bundle, but basically it's,
Also got in the bundle, yes.
but it's known as estoppel by deed. Whether it is estoppel or not is
That's right.
a categorization argument rather than an argument
Yeah.
of principle. Yep.
And then 30, the board said it's suggested in Chitty that there's little point in now preserving any separate category of estoppel by deed, since the basis of the estoppel appears now to be covered by estoppel by representation or convention. That may be going too far, and then various examples of why that's going too far are given. And paragraph 30 has been incorporated in the corresponding paragraph in the latest edition of Chitty.
Right.
Well, the principle set out by Lord Justice Moore-Bick in quoted on page 4971. Page 4971, there's a quotation from Lord Justice Moore-Bick in PK,
Yes,
which effectively sets out the principle. Is that right?
that's right.
And that's it, really, is it?
PK.
Do we need to fish about in all these other cases? That's simply the principle, isn't it?
Well, the Privy Council went into historic cases because of Greer and Kettle, which had been...
But do we need to... What are we getting out of this, apart from the point you've made? Why are we looking at Greer and Kettle?
Well, you get out of it, my lords, the proposition accurately stated in the head note, which is,
Yeah, quite.
and it applies to this case, the way it applies to this case is to confirm the correctness of the judge's very succinct analysis.
Yeah, well, I understand that.
When he said that
All I'm concerned about is not going down unnecessary highways and byways like Greer and Kettle. You say prime site and what we've been taken to establish the principle that you say the judge rightly applied,
yes,
right? Fine.
exactly.
Okay.
And
Got that.
it's unlikely that the judge was aware of prime site and Lavarello, because if he had been, one would have thought he would have raised it, unless he found it between the oral argument, in which course of which he'd expressed no interest at all in our estoppel arguments. We had pleaded estoppel. We'd gone into it in some detail in our written submissions at the end of the trial, including in particular our written response to the afterthoughts which were inflicted on the judge by Mr. Hockhauser after the trial had finished, and which we responded to. They're in the Bible. But the judge expressed no interest in estoppel during the oral argument, and I suppose in that case it would have been odd if he had referred to estoppel to justify his approach.
Can you show us the document which you say involves estoppel? Where do we find the statement?
Yeah.
I think there are several. But
Yes, my lord. I'm just scrolling up the. (2703).
that looks.
If your lordships would prefer the hard copy bundle, they'll all be in the same one, I think.
That's a hard copy now.
No, I'm doing it on screen, my lord, but
2703 is in volume 15.
yeah, is in, yes. They're all in, they're all in volume 15.
That's the sold note.
Volume 15, tab 5.
I mean, these are all quoted in your case, aren't they?
Yeah.
Yes.
(2703).
Yes, I see.
Yep.
The bought and sold note.
Yeah.
Purchaser Chen Mei Huan.
Yeah.
Consideration received $40,000. Oddly enough, signed by Mr. Rather than by
She signs at the bottom.
The bought note
then bought note.
signed by her. Yeah.
She signed the bought note.
Yeah.
And then the next page is the transfer,
Consideration
2704.
paid to me. Yeah.
Consideration of the sum of $40,000 paid to me by Chen Mei Huang.
Sorry, which page is that?
The next page.
2704, my lord.
And then it's formally approved, signed by both of them on the subsequent page.
Then 2705,
Yep, we've
I
seen.
mean, these are all just,
Respective
they're
of
set
text.
out in your case,
resolved
word
to
for word.
approve the transfer, signed by both of them.
Can we not just look at the case? I mean, do we need to look at the documents? They're all set out in your case.
Fair, Lord.
I did ask, yes,
Yes, I beg your pardon.
They're all in our case. And then the statements against interest, I would invite your lordship to bear with me while we just look very briefly at them. If we go to tab 16 of that bundle,
Right. There's an initial problem, but that's put right.
2730,
If we turn the page.
we've included the Chinese
Fine.
versions
Well,
of
we-
these two documents because it is important in view of Mr. To see that these were documents in Chinese which Mr. signed.
I understand.
The English translation
Yes. It starts at
shows that there's
2734.
it's a chairman's report, 2734. And if we go down the chairman's report by Mr. who's the chairman of the meeting,
Yes.
we find that starting at the bottom of 2735, paragraph Roman 8 of his report, he confirms he's never issued or signed any trust documents concerning the shares, also never managed any of the company's shares on behalf of any other person. And then 9, he confirmed the entire 40,000 shares transferred to Madame Chen belonged to him personally and no third party's interest was involved. After the transfer, all the said 40,000 shares were vested under Madame Chen's name, and Mr. Did not retain any right or interest. Now, he signed that in Chinese, and this is simply the English translation.
Yes.
And then the next day, makes what's referred to in the pleadings and so forth as the declaration.
Yes.
2738, this again is
And we look at 2742. Yep.
a Chinese document.
Yes, we look at 2742. It has the translation, yes?
That's right.
Thank you. And we have what, paragraph 5? The paragraph 5?
5, I transferred the entire remaining
Yeah.
shares to Chen Mei Huan. And then
Yep. Anything else on that?
on the next page, because this is a 2-page
Right.
document,
Yep.
There's paragraph 12, isn't it?
paragraph 12,
Yeah.
solemnly declare and confirm, whatever that is in Chinese,
We appreciate
that those shares belong to him personally. After the transfer, they shall be under the name of
Yes.
Madame Chen in entirety, and I shall not keep any rights.
Right.
So those are quite clear.
So these are the essential documents. First of all, the documents actually affecting the transfer and recording them. And secondly, the statements against interest. Yes?
Yes,
Fine? Okay.
there's nothing more startling about the fact that Mr. and Madame Chen signed those documents even though the consideration hadn't changed hands and was never intended to change, than there was anything startling in the eyes of the board about Mr. Meraki and Mrs. Meraki having executed the Mr. Meraki having executed the assignment to Mrs. Meraki's company.
Yeah.
Well, the judge did not proceed on the basis that it was never intended that the consideration should change hands, did he? Unless I misunderstood him. He proceeded on the basis that the promise was to be taken at face value and amounted to the consideration.
Lord, I
There
wouldn't.
wouldn't have been any consideration if he'd proceeded on the basis that it was never intended that money should pass. The whole document on that footing would have been a sham, which is not what he decided.
Well, it was never intended in Meraki that the consideration should be passed, and the board.
Well, that's
That
right,
was
but
the board's view, and the board said there was no question of sham, no question of sham had been raised.
yes, but
Same
you're
in
putting it
this
on a different
case.
basis now, aren't you? This case was not before the judge, and as I understand it, estoppel in relation to the fact of payment was not a point that you ran before the judge, or is that wrong?
Well, may I ask your lordship to look at what we actually pleaded? What we pleaded was, I'm afraid it was very, very brief, but in my respectful submission, sufficient. We pleaded that they had executed the documents. Well, I think I better, rather than paraphrasing it, it's so important I should show it to you.
We, in the end, have to keep our eye on the ball, and this is important, because the issue ultimately is whether the judge was entitled to reach the conclusion that he did. The issue ultimately is whether the judge was entitled to reach the conclusion as he did in light of the pleadings and the arguments. So I can quite see why you want to take us to the pleadings.
Yes.
Yep. So where do we look?
It's bundle 3, tab 14.
Okay.
Bundle 3,
Tab 14, page 332, yep.
that's, in my set, that's headed applications bundle. Oh, I see. 2 bundles.
Life wouldn't be the same if there weren't 2 bundles.
There's 3 and 03.
Yes. This bundle 03.
It's 03, bundle 03, the one next door to 3.
That's just to confuse the enemy.
Yes. Confuse friends as well. Okay, what do you want us to... Oh, sorry.
It's on page 344.
344?
344.
Okay, 344. Tab 14, page 344, yep. Tab 14.
This is in paragraph 9, which pleads 2 estoppels, and it pleads them in parallel terminology. The first estoppel, page 341, called D. Further or alternatively, ever since the 1996 oral agreement, Chen and have had a mutual understanding and/or common assumption that the oral agreement existed, was effective, and would be performed by Mr. Parties have organised their affairs in reliance upon the same. Well, that went by the board when the judge rejected the 1996 oral agreement. And then P, page 344,
Yep,
Q rather, sorry.
thank you.
Further or alternatively, since the date of transfer, that's the 4th of October 2011, Chen and had a mutual understanding and or common assumption that 1, the instrument of transfer, 2, the 4 October...
Yeah, all the documents were
Yes.
effective.
and existed and were effective and organised their affairs in reliance upon the same, and he's now stopped from denying the contents and effect of those documents. Now that was put as a reliance-based estoppel or estoppel by convention, if one had put a label on it.
Yes.
But
Did the convention include an agreement not to pay.
Well, yes, I mean, that's
But it was an agreement that they had paid.
I beg your pardon, Lord?
The agreement was that they had paid.
An agreement not to pay twice.
Yes.
Yes, yes.
But that's an estoppel, it may be said against you. It isn't actually doing what the judge did, which is to say these documents simply are effective as a matter of contract.
Well, that isn't, with respect, exactly what the judge said, my lord. If we look at the way he put it, which is why I was going to start by looking at the judgment.
Where do we go?
Volume.
Well, I'm quite keen on your case. Paragraph 20, you set out what Mr. Justice Bannister said in this connection, I think.
Can we take it from the... Is it in your case, as Lord Clerk says, hopping around these unfriendly bundles, if it's all in your written case, we do better to look at that, don't we?
38 and 39.
Is it what he says in 38 and 39? Or is there more than that?
Sorry, my lord, I'm hunting for my
Okay, you go on hunting.
my written case.
Well, are you taking us to paragraphs 38 and 39 of the judgment? Well, it looks in 38 and 39. Yes. That's where, is that right? Is that the paragraphs you rely on? Of the judgment, 38 and 39.
In dealing with Mr. Hockhauser's point that the transfer was gratuitous and therefore there was a textbook
Yes.
presumption of resulting trust.
Yes.
He says that proceeded on a false premise. It wasn't gratuitous. It was for a consideration evidenced by the bought and sold notes and, of course, by the transfer itself of $40,000. The fact that that hasn't been demanded or paid doesn't mean that the transfer was gratuitous, unless, which has been neither pleaded nor argued, the documents are shams. All that's pleaded is Madame Chen didn't pay any consideration because it wasn't intended she should keep the shares. That's not sufficient to negative the contractual effect of the documents which the parties signed. Now, had he just cited or referred to prime site and Lavarello, that would have made complete sense in terms of the reasoning in that case. And he said, in my judgment, the legal and evidential burden is on to show reason why the documents which he executed should not have carried into effect the agreement which they evidence on their face. He fails to discharge the burden.
Page 182.
Thanks.
181 to 182. Mm-hmm. It isn't quite the estoppel by convention that you were contending. He basically rejects all the oral evidence and falls back on the documents and says, I take them at face value. Right?
When your lordship says he rejects all the oral evidence, he certainly rejected all Madame Chen's oral evidence that the shares have been hers ever since 1996. He's rejected that. But
this is consistent with there being an outstanding obligation to pay $40,000, these two paragraphs, whereas your present submission is not consistent with that. Your present submission is that it is treated as having been paid.
No, my lord, I'm not intending to submit that. Oh. I'm intending to submit that the consequence of these documents, read in a sensible way, is exactly the same as the consequence of the documents in Lavarello.
In other words, treated as having been paid, though actually we know it wasn't.
Yes, the trustee in bankruptcy claimed the money from the company on the basis that the fact that it was not paid and never intended to be paid, and as Mrs. Meraki says, that was because it was all hers anyway,
yes, but
meant that he could now claim it from the company on behalf of Mr. Meraki.
Basically, Mr. Justice Bannister leaves open, presumably because it wasn't argued, the question of whether the $40,000, if it hadn't been paid, could be paid. But you say that if that point had been raised, the correct answer was it couldn't be demanded because the parties had agreed it had been paid.
Yeah.
And that's the end of it. Yeah. But subject to that point, there's nothing you quarrel with in what the judge says. But I revert to the point that, is this consistent with what your pleaded case is? Because the argument is that it's not open to the judge to fall back on the documents and say they were effective, because that wasn't the way either party argued the case or pleaded the case. You've taken us to two passages in the pleading, in your pleaded case, that you say are good enough.
Yes, the second passage.
Particularly the second passage.
Second passage, which is further or alternative.
No, we've read that. That's Q.
Yep. Alternative to the rest of the claim, which is
Quite.
so tediously expounded.
No.
The
Your point is
the
that
document.
your point is that we can stop effectively with the words in Q existed and were effective.
Yes.
We don't really need the rest.
No.
Yes, I mean, presumably what's really being suggested is that it was the case, it was argued that the documents should be applied according to their terms. The fact that arose on one legal analysis rather than another makes absolutely no difference if the relevant fact was that they were intended to be taken at face value. Right?
Lord, I was given a hard time by the judge on day 6, and the judge put it to me that I had never put these documents to Mr. And I said, but they were authentic documents, which Mr. admitted. There was no reason for me to cross-examine about them. They were part of the accepted factual and documentary story.
I'm puzzled by the judge's statement that in paragraph 38, it was never pleaded the documents or argued the documents are shams. All that is pleaded is that Madam Chen didn't pay any consideration because it was not intended she should keep the shares. Looking at the statement, amended statement of claim in bundle 3, tab 11, that's pleaded at the top of page 297, paragraph 16, but then it's pleaded in 17, Mr. Nung didn't properly understand the legal effect of the declaration. And then page 34, paragraph 34, page 300, the claimant avers the alleged transfer is void for the reasons set out below. And 36 is, Mr. Nung never intended to transfer the beneficial or legal ownership in the shares to Chen. Yes. She was to be his bare nominee. Bill, doesn't that amount to a statement that the transactions were a sham?
No, my lord. What underlies that, and indeed what underlies the whole of this amended statement of claim, which was never, the only way it was a need for amending was when Madame Chen was joined as a party. The red amendments simply add her as second defendant. The substance of the statement of claim always remained the same.
Yes.
What was being said was that the transfer to Madame Chen was actually void because it was contrary to the terms of a charge of the shares which had existed since 2001.
Anyway, does paragraph 36 amount to voidness? I mean, a bare nominee does hold the legal interest. Does paragraph 36, in fact, I mean, that is presented here as a reason why it's void, but does it actually have that effect in law? Because a bare nominee does have the legal title.
I know, but that's not what he wanted to establish.
It seems to have been Mr. Chen's case that there was a perfectly valid transfer of the legal title.
Yes.
And he then relied upon his factual narrative, which the judge rejected, as suggesting that there wasn't a transfer of a beneficial interest, that he retained that. But the factual narrative was rejected, so one is simply left with the legal ownership and no proved equitable interest retained.
There's an inconsistency between the words "all legal," the first sentence of 36, and the second sentence, because if she was to be his bare nominee, she was to have the legal ownership.
Yes,
Whereas the first sentence asserts that the legal ownership passed,
yes.
or at least intended.
To understand this, and one can't fully understand it because it actually doesn't make sense. But to understand what the pleader was trying to do, we have to start at para 26 on page 298, bottom.
In answering, it would be helpful to me at least if you were to answer Lord Mance's point or suggestion that there's a strong suggestion that it was never agreed that that this money would be paid,
Yes.
and to that extent, that agreement was a sham.
Well, the Privy Council, the board didn't consider that
We're not talking about the board.
the Navarello transaction was a sham, even though there also the money was never intended to be paid. What one needs to distinguish carefully is transactions of this kind which are designed to deceive third parties, like the transaction in Tribe against Tribe, where the finding of fact was that the father and son had agreed that the company shares would be transferred to the son under a transfer for substantial consideration, but that after the problem with the landlord had been disposed of, the son would retransfer them to the father and the money would never be paid. And it was found as a fact that this was an illegal agreement designed to deceive the father's landlord and to show that the father had no assets which would make it worth suing him for dilapidations. And then the question in Tribe and Tribe was, did the fact that the father had repented of that plan mean that he could rely on it to defeat the presumption of advancement in favour of his son? And they held that it did. And
But your case
nobody
is that
doubts
this is
Tribe and Tribe.
a contractual agreement to proceed on the basis that the money had been paid.
Yes.
I think the word sham is quite dangerous because a document can be perfectly genuine. It was in Tribe. It was intended to transfer the legal ownership. It wasn't a sham. It was an artificial transaction, not all of whose terms were contained in the document.
Yes, and Lord
But it wasn't, a sham is a very dangerous word.
Exactly, and I think Snook...
Snook and West
makes
Riding,
that
yeah,
clear.
yeah.
We've got Snook in the bundle.
I'm not surprised.
And
Not more besides, but I
Lord Justice Millett in Tribe and Tribe, I don't think uses the word.
the word sham is not used in that case, no.
But
In fact, I think the whole point was the transaction was genuine. It wasn't, the legal interest was transferred. If it had been a sham, it wouldn't have been.
It wouldn't, if it hadn't been transferred,
Yes.
it wouldn't have achieved.
No,
its
but it
objective.
wouldn't have been effective if it hadn't transferred.
But the plea, it is essential to understand that the amended statement of claim is based on the nonsensical legal proposition that the transfer was void because it contravened the terms of the bank's equitable charge. And if we look at para 26
Yeah, exactly.
Yes.
on page 298, we see that in a letter dated the 20th of July from the bank's solicitor to Madame Chen, the bank stated that the alleged transfer, if it did occur, was void. Now, your lordships should look at that letter. It's not quite correct.
Isn't this an alternative reason for saying it's void? It's not the only reason. And this leads up to paragraph 35, but paragraph 36 seems to depend on the...
But it can't be void because the second sentence of 36 says that they did intend to transfer the legal ownership. So,
But I mean, everything from 34 to 42 is arguing that the bank's equitable charge renders this
Yes.
void. It's not asserting in 36 a case of sham
Yeah.
or anything of that nature.
yeah, I agree.
Yes.
To show your lordship the letter from the bank. I'm hampered by having lost.
Why are we looking...
By having
Sorry,
lost
Mr. MacDonald, why are we looking at the letter from the bank? Why are we looking at the letter from the bank? What's it go to?
Well, to show your lordship that when this pleading was formulated, and it was never subsequently amended, the bank were saying that the transfer was actually void.
Yes. So the first sentence of paragraph 26 you say is accurate. That is what they were saying.
Yes.
Yes.
Okay, well, I'm not sure we need...
No, well,
We need to see that.
necessary later on, I can.
If necessary, we can see it later.
Saying to my lord, I am hampered by the fact that
Okay.
by leaning on my machine, I have come out of the electronic bundle, and I need to go back into it.
I'm amazed if you're using the electronic bundle, because I thought we were going to use... I thought it has different numbering, doesn't it, from the hard copies, which I thought we were going to use.
Sorted out.
No, it's certainly the my version of the electronic bundle, as of this morning, has accurate numbers.
Does it?
Well, so far you've been quite accurate, yes.
Okay, now, wait a minute.
I do notice your lordships don't appear to be using the electronic.
Well, I tried to use it and I got a completely different document.
Right. Well, I'll.
I think there may be more than one bundle.
Yes, I think I may be right.
Yes, that's.
Find an updated bundle. I'll look around. How do I know which is which?
One bundle.
Trial and error. Right. Where do we go from here? Keeping our eye firmly on the ball of the issue.
Sorry.
Keeping our eye firmly on the ball of the issue we're trying to consider. Where do we go to next? Oh, great. It's quite difficult. No, I just have to get the right one by luck. Yep. So you say you pleaded it. What about in the... And you said you weren't obliged to put the documents themselves to Mr. Ng,
Yes.
because they spoke for themselves, and anyway, they weren't really in dispute.
Yes.
Okay.
I think the next point
Why weren't you obliged to put them to him?
I wasn't challenging them, my lord. They were admitted documents. It was a question for the court.
He was challenging them. Now, you certainly put the basis of his challenge. You challenged the basis of his challenge. Don't you have to put what your case is about the documents?
With respect, no, my lord. He didn't. All he said about the documents was that he didn't understand their legal consequences. I'd be very surprised if any of your lordships, faced with that situation at the bar, would have cross-examined a witness who said he didn't understand the documents as to why didn't you understand them, isn't clause so-and-so perfectly clear.
Well, I suppose it depends on whether it's important to the case that it's part of the case. But you say it wasn't part of the case, so you didn't need to put it. Okay, understand the point.
Mm-hmm. I heavily challenged his account of the Kotai Strip project.
No, I understand.
And indeed,
Not successfully, but unfortunately your own case met exactly the same fate. You successfully challenged the account.
yeah.
Yep.
But in my submission, we did that entirely fairly. May I, since a major point was made out of this by the Court of Appeal, and my learned friend, I think, will seek to run it again, show your lordships the cross-examination on that
Yes.
This is the cross-examination on Mr. Ng's factual narrative as to why there was a retained equitable
yes.
interest.
If we can look at the transcript of day 1.
Yes.
5, tab 5.
One. Page.
It disappeared.
Which page, Mr. MacDonald?
Well, let me start at page 602.
Thank you.
The,
You want to start at the beginning, right? Yep.
Can I say, by way of preface, that at the pre-trial review, the judge had directed that there were to be no opening speeches,
Right.
and that the skeletons were not required, but if they were put in, they should be limited to 3 pages.
Right.
We put in a 3-page skeleton which started by reserving the nylon point for a higher court, and then simply went on with some very interesting authorities about handwriting evidence and the use by their handwriting expert of statistics, reference to authority and so on. And that needed to be laid down at the outset because we were going straight into the evidence,
Yes.
and it was a basis for my later
Anyway, which page are we on? Which page are we on?
602.
I wasn't going to show you, lordships, the skeletons. We're on page 602, I think.
Right. And where do we go to next?
So we start off with housekeeping issues.
Yeah, well, we really don't want to read about those, Mr.
Mr. Um's cross-examination, there's nothing before us
Right. Excellent.
about the legal issues.
Yes.
At page 627.
Good. Right, now where do we come?
And
Yep.
I started off by putting to him the first document which he'd exhibited to his witness statement, which was an autobiography of Dr. Stanley Ho, which included various statements about Mr. which in his witness statement he relied on. And page 630, his passage which he'd exhibited started at page 147 of the book, bottom of the page.
Yes, well, what are we getting to of relevance?
Well, we're getting to this passage, which goes on for some 5 pages.
Yes.
It's a good start to the cross-examination because it ended up with Mr. saying that everything it said in the book, which he'd relied on, was actually untrue.
Right.
It wasn't an autobiography, as it had been presented in his witness statement. It was, he said, by a novelist. So we got that out of the way, and Mr. Hawkins said he wouldn't be relying on that
Well,
at all. So we then came on to straight into the Katai Strip project, page 634.
yes.
Line 8, did there come a time when you were proposing to build a new building near the hotel in Katai Strip? Yes. Who was your partner? Myself, I had no partner. And then I established that it was to be carried out by a company called Chong Gold and put it to him 19. That was a company in which equal shareholdings were held by you and a person called John Gong. He invested 100 million US into Chong Gold. He was your partner in Chong Gold, wasn't he? Yes, he was a shareholder.
Well, what is all this going to, Mr. MacDonald?
It's all going. This is my challenge to the Katai Strip story.
But
It takes us right up to the documents executed on the 11th of October.
Yeah, but
If your lordships would prefer to read it
well, I think we.
on to yourselves, of
Well,
course.
yes, I think what we want to see is the issue is not everything you put to him, but what of relevance in relation to the issue for us. And it's the issue for us we should be concentrating on, which is that it wasn't open to the judge to come to the conclusion that he did.
Yeah.
All this seems to be
It was
background.
open to the judge to
I
disbelieve his Katai Strip
know.
story.
Well, I don't think anyone's challenging that it was open to the judge to disbelieve him. What they're saying is it wasn't open to the judge to make a positive finding that the documents were valid and effective and performed and did what they said they did. And I'm not sure any of this is helping us on that issue.
Well,
We're not having a rerun of the trial. We're having a narrow issue here, as I see it.
well, I think if I've understood the point.
You're picking up on the point that it was open to the judge to disbelieve Mr.
Yes, I'm sorry. Perhaps.
No, well, perhaps
I
I'm.
think that is challenged
Yes. Well, in that case,
in
I'm
the respondent's case.
But if that's not what's of interest at this stage, let me jump back to the submissions in our case about
You think so? I think we should hear from Parker. I think Mr. MacDonald's position is this. It's a perfectly fair answer that you give to me that that's an issue. But I think we'd rather have Mr. Parker about why that it wasn't open to the judge to disbelieve Mr. Ng, and you can then deal with it in reply.
yes, you
I think that'll be.
don't want to hear Mr. Parker now on that.
I think not. I think we'll hear him in due course on that.
We'll carry on.
So I think we'd like to limit you to, because we'd like to hear from Mr. Parker first on that, we limit you as to why you say the judge was entitled to make the finding that he did, i.e. why the Court of Appeal was wrong to say it wasn't open to the judge to make the finding that he did.
Yeah. Well, as your lordships know,
On the positive finding on the documents.
we say they made two fundamental errors. Number one, there was what we call the common ground fallacy.
Yes.
That because she had said in the case which was rejected that she had the beneficial interest all the time, which meant that, logically meant that the beneficial interest wasn't transferred to her in 2011 because she'd already got it. And that Mr. Said that he hadn't transferred the beneficial interest to her in 2011. Therefore, it was common ground that the beneficial interest never passed to Madame Chen, which in our submission is obvious nonsense. It's a fallacious piece of sophistry.
Because?
More importantly, the issue that went to trial, which I think my Lord Newmarket just put to me, we dealt with that in our case at page 73 of the bundle one, yes, it must be.
Thank you.
And where they're attacking the Court of Appeal's reason.
Yes?
He said the issue that went to trial was for a determination of the beneficial ownership of the shares prior to the transfer. Top of page 74. That's Court of Appeal at para 56. We say that one was not right because they had overlooked or ignored the agreed statement of issues. Under the BVI rules, as indeed is the case under our own rules, the parties were expected to agree a list of issues at the case management conference, and that had been done, and the list is in Bundle 4. It's the first document in Bundle 4. Yeah. But we've quoted the relevant bits in the case. If
Paragraph 41. Yeah.
Yeah.
But you say that the issue that went for trial was not limited to the point identified in the first sentence of paragraph 56 of the Court of Appeal. Is that right?
The issue identified by them in that sentence quoted at the top of the page wasn't an issue at all. It wasn't part of the...
Well, it was part of her case that the beneficial ownership had always been hers. But ultimately, the question was, on the facts found, who was entitled to the shares.
Yes. Well, yes. True. The second, third, and I think perhaps fourth issues were to do with Madame Chen's claim, which was went out of the window.
If we look at the party's case in the statement of issues in Bundle 4, Tab 4, page 408 to 409, I suppose the point that can be made against you is that in summarising the claimant's case, it said that the transfer was invalid, and in summarising your case in paragraph 6 at the top of page 409, there's nothing saying that the transfer was valid. Indeed, you say the claimant never had the beneficial interest, but only the nominee legal interest.
Was your Lordship, did your Lordship refer to a page 409?
408 and 409 in my bundle, which is tab 4.
Paragraphs 5 and 6
paragraphs 5 and 6
of the PTR.
This is the
claimant's
Proceedings before the Court of Appeal.
Mr. Skeleton argument for the pre-trial review 6 months later.
I see.
6 months after the CMC.
So I'm looking at the wrong document. I beg your pardon.
Yes.
The correct
my
document
fault. Is tab 1.
You're quite right. Yeah, I jumped the wrong document. Sorry.
And this document was in accordance with the rules, and we've given references to the rules. This was presented at the case management conference on the 22nd of April 2013.
You rely on paragraph 5.
Yes.
Yes, I see. Yes, I understand.
No issue as to whether there was a valid transfer of the legal interest. Therefore,
right.
No point in cross-examining.
Was the alleged transfer a valid transfer of beneficial interest in the shares? And it actually rolls up two questions. The term valid is included because of the issue on the pleadings as to whether the transfer was valid or, as Mr. still pleading, void. This was never pursued at the trial. The whole nature of the case changed when we got Mr. written opening for the trial.
The validity issue disappeared.
It was never pursued. It's still there on the pleading, but it was never pursued because presumably Mr. Hochhauser realised it was nonsense. And so Mr. Hochhauser's skeleton, or written opening as it was called, was entirely about resulting trust, which was the first time that expression had been introduced in the case. There is no pleading of resulting trust.
Understand.
There is no suggestion at the CMC that the case was about resulting trusts.
Well,
Mr. Hockhauser's three-page opening, as directed, was all about resulting trust.
What's the reference to that? Is that in the bundle? Is it in the bundle?
It is indeed.
but what's said against you is that you both parties agreed, both parties' case agreed on the question, answer to question 5. It wasn't a transfer of the beneficial interest. Mr. Ng saying it because it wasn't intended to be, he said, and you because you said you already had the beneficial.
Yes, this is the common ground fallacy.
Why do you say that's a common... It's all very well calling it a fallacy and so on. Why is it a fallacy?
May I just give Lord Clark the reference?
You may.
To the opening statement. It's volume 5, tab 1, is opening statement by Mr. Hockhauser.
Thank you. But you've said it's a fallacy and nonsense, but why is it a fallacy and nonsense?
I've tried to formulate this accurately in para 5 of the case.
Yes.
Fallacy lies in describing a proposition as common ground
Yep.
when it had been asserted by the respective parties for diametrically different reasons, which were each denied by the opposite party, and Madame Chen's reasons for asserting that had been comprehensively rejected.
Well, there was no common ground, in fact, because Mr. Ng was saying that there was no transfer of the beneficial interest, and he, because he had retained it, and Mrs. Chen was saying there was no transfer of the beneficial interest because she already had it. So the net result of those submissions was diametrically contrary to each other.
Of course.
One was saying, I've got the beneficial interest as a result of this transaction or after the transaction, and the other was saying, I've got it. So on the essential point, where did the beneficial interest end up? They were at odds.
Exactly. And for the judge looking at it, correctly perceived that the Madame Chen was saying, I've got the beneficial interest now. I always had it, but further or alternatively, Mr. is bound by the documents.
Oh.
He was saying, I've got the beneficial interest now because although I admit I executed the transfer and that sort of thing, I never intended to pass the beneficial interest.
I reserved it.
Now, where...
Actually, he doesn't say that in his statement of claim. His statement of claim says, I transferred the shares to her and she promised she'd return them after 6 months, which is a completely different
Well, that
case.
may give rise to a legal analysis which one wouldn't criticize him for not appreciating, namely a subsisting equitable interest because of the absolute character of the obligation to retransfer.
Well, it gets one into, was this a quist-close trust? In other words, was there a resulting trust, but of a quist-close nature?
Well, does it have to be close? Surely the position is simply there was an absolute obligation, according to his case, to transfer the shares to him in X months. And that being so, there is an equitable interest pending execution of that undertaking.
Yes, I think the analysis would be in terms of quist-close trust. The shares are transferred for a limited purpose, and at the end of the time, when the time to retransfer them arises, they become held in trust to return them.
Does any of this help on the issue we've got to decide? What, if he'd accepted Mr. Ng's evidence with the right analysis of the arrangement, that seems to be a long way away from the issue we have to decide, which is whether he was entitled to accept, to make the finding he did, which is what we're concentrating on at the moment.
Yeah.
Is that right?
Well, he in my submission, he was entitled to
I know,
to
that's what
conclude
we're-
that these these are, on the face of it, contractual documents.
Yes. But that's the point.
I suppose that the intermediate position which Mr. Nung was running, namely, there's an agreement to transfer the shares back after 6 months, is actually consistent with him accepting that the documents mean what they say, legal and beneficial interest pass, but I attach to them a contractual agreement that after 6 months there will be a return. And so on that basis, he may have been asserting, well, one view of these documents is that they transfer the beneficial interest, but there is this further agreement, and the judge disbelieves him on that and rests on the documents.
That's right, and that's why I mentioned the quis-close type of resulting trust, because there the whole beneficial interest passes to the recipient, and the trust, the quis-close trust, which is
Arises on an event, doesn't it?
which is unanimously accepted to be a form of resulting trust.
Yeah.
It arises or results when the purpose is finished.
Yeah.
So between the original transfer and the quis-close trust arising, the beneficial interest is in the transferee.
Well, it's got to be, 'cause otherwise you couldn't transfer it back. Yeah.
But
He divests himself
The
of
whole-
he divests himself of any present interest. That's,
the whole story about the obligation to transfer back really falls to the ground once one looks at the details of the undeniable facts. The 6 months would have expired on the 4th of March 2012. There was never any request or demand by Mr. For the shares to be retransferred.
now we're going into the question.
Contrary.
Yes, now we're going into the question of whether he was believable. But what you have adopted what Lord Mance put to you and say it was open to the judge to make the finding he did, not least because it was consistent with Mr. Ng's case, albeit only in part.
Yes.
Yeah, okay, got that. So just concentrating on why it was open to the judge to make the finding he did. Is there anything else in the cross-examination or in the written argument you want to take us to support that proposition?
Yes, my lord. First of all, about cross-examination. We started looking at
We did.
cross-examination on the Katai strip.
But I thought you accepted that you had not put the documents to him because you said, and I understand your argument, that it wasn't necessary given what was disputed and what wasn't.
There was
So,
yes.
so if you accepted that you didn't put it to him, there's not much point in showing us the cross-examination for its absence.
No, what I did put to him, though, was that the Katai strip project had been dead in the water since April 2011.
That goes to the point on which I think it was indicated that one would wish to hear from Mr. Parker first.
Yes. And I took him through the story after that. I mean, your lordships will find, and it's in the case, that he first of all tried to say, oh, well, the feasibility studies were, I had the feasibility studies done after I'd reported Mr. Gong to the police, and I showed him that they were actually done 6 weeks earlier, which he accepted. He accepted that he had been the subject of extensive unfavourable publicity in July 2011 over a so-called Ponzi scam alleged in the newspapers. And he accepted that he was very heavily indebted. Mid-2011, he had been made to enter into a set of agreements with the banks in Hong Kong, under which he owed a total of, I think, 250 million.
Where does all this take us?
It takes you to the suggestion which was put to him that the reason why he transferred the shares to Madame Chen was actually because he was in a financial crisis.
But you've got the judge on your side on that.
Yeah.
So
Yes.
there's hardly any need to make the point now, is there?
Now I'm trying to remember what it was, Your Lordship, wanted me to pass on.
What I was asking you to was to say, what I was saying was, the issue is whether the judge was entitled to make the finding that he did, namely that the documents you took us to earlier on were effective on their face. And you've made submissions about that, and I think we clearly have your argument, and it's been assisted by your full written argument. You've taken us to the statement of issues, and I just wondered if there's anything else in terms of the cross-examination or the written argument before the judge which is relevant on this narrow issue.
Lord, I'm very grateful that I know what I was intending to move on to, which is the written closing submission.
That's very helpful, thank you.
Bundle 5, tab 4.
Outline for closing, thank you.
These were handed up on day 6 when I started my submissions, and my learned friend, Mr. Hockhauser, who of course made the closing speech, handed up his closing written submissions. So although they're in the bundle before mine at tab 3, they were actually, we didn't see them until after we had concluded our submissions. Now, mine starts with a chronology, and then
Yes.
we say central question, simple one, answer obvious. No doubt shares validly transferred to Madame Chen have been and are validly registered in her name. In order to succeed, he has satisfied the court vested in her on trust for him, or that she promised to retransfer them to him. He doesn't rely on a bare resulting trust. By that we mean a trust based on nothing but the classic presumption in relation to gratuitous transfer,
In a way, for the purpose of the case, today, you can almost stop in paragraphs 2 and 3.
Yes.
3, can't you?
May I just...
But yes,
this is very short.
No, all right. It is pleasingly short. Yeah.
And then we deal with the improbability of his story.
Yes.
And then we come on paragraph 19.
Valid transfer.
Regardless of sorry.
On this analysis, the valid transfer to Madame Chen was when?
4th of October 2011.
So this argument was based upon the transfer in October, not the previous one.
Oh, no.
Okay.
So how long is this after the trial, or this is the closing, but what
This is
happened?
on day 6 of the trial.
I see, it's all part of the trial.
Was any objection?
Absolutely.
Was any objection taken to this by was it Mr. Hockhauser was against you?
Mr. Hockhauser tried to object in the course of oral argument, but then apologised for having missed the second estoppel in paragraph 9.
Is that in the transcript?
It is.
Perhaps we could see that.
Yes. Note, if your lordship will bear with me, I've got a note of where that is in.
Should be somewhere in the same bundle.
If you want to take us to it later, Mr. MacDonald, don't let me hold you up now. If perhaps your junior can find it, but...
I can find it quite quickly in the transcript of day 6, even though I can't find my note.
Paragraph 7 is very good.
Paragraph 22 of the closing submission seems to be also relevant.
Tab 2 is the...
597.
Page 1625 of the bundle,
Page which,
pagination of the transcript itself, it's page 211. This is day 6 in volume 9, tab 2. Volume 9, tab 2, page 1625.
thank you. Yes.
Right.
I'd only picked up the estoppel in relation to the 1996 oral agreement. So if there's an estoppel that's pleaded, I do apologise. And Mr. Justice Bannister said he mentioned it again in submissions.
Sorry, this is page which again?
1625.
1625.
Oh, yes, I see. Yes, I'm sorry. Yeah.
My Lord, I'll save this perhaps for reply, depending on what my learned friend Mr. Parker says, but I'm afraid that we will have to suggest that Mr. Parker also missed it in his skeleton argument when he took over the case from Mr. Hochhauser in the Court of Appeal, and in his skeleton argument said Madame Chen could have relied on an estoppel based on the documents, but if she'd pleaded that, we would have had to plead that they were shams. And he hasn't admitted ever that he missed it, but it's fairly obvious to us that he must have done. But we'll come on to that if we have to. But Mr. Hochhauser hadn't addressed it for that reason. But it didn't stop there, because going back to, if I may just try to conclude this before the adjournment, going back to Bundle 5, Tab 4, page 597, we submitted that the wording of the document made it explicitly clear his intention was to transfer the shares outright without retaining any interest in them.
Which paragraph is that? Which paragraph?
19.
19.
Okay.
Sorry, Mark. Then that was confirmed by him well after the alleged 6 months period by such documents as his letter to Kern Gore. The importance of that letter to him, as well as to Kern Gore and Madame Chen, was that Kern Gore had always been essential to the management of the cash flow of both hotel and casino, and his own explanation of the letter is that he wanted to make it clear the responsibility for managing the cash flow ought to be regarded as Madame Chen's alone. And, my Lord, I can show you if necessary, my cross-examination of Mr. on that letter, in which he volunteered that at that stage, and this is July 2012, he wanted Kern Gore and everyone else to know that he was no longer responsible for the debts of the hotel. So far from saying this all belongs to me, and she'd promised to return it to me and that sort of thing, he was actually, his oral evidence under cross-examination was, no, I wanted to make it clear it wasn't mine.
It seems to me that the point made by Lord Mance about it being part of Mr. Ng's case that the documents were genuine is rather supported by the way Mr. Hochhauser put the case on page 582.
Page
582 of the same bundle, of this bundle.
502.
582. Paragraph 67 to 68.
Oh, I see, sorry.
That underlines the fact that Mr. Ng was saying that I did transfer the shares,
Yes.
but subject to, as it were, a reservation, whether
Yes,
it has a quis-close effect or not needn't concern us, but
exactly.
really all in the first sentence of 68 in a way.
But on the other hand, he then goes on over the page 584 to say that it was there was a resulting trust.
Oh, yes.
But he says it seems to be what I've called a quis-close type resulting trust.
Maybe.
Because he says 75B transfers for a legal title for a specific purpose. and then says there was no intent to transfer beneficial title, which is a bit different from what appears in the
Well, as Lord Sumption says, if it was a contract by him, by her, to transfer the shares back, then you could say it was a classic trust
or
based on
simply
a vendor
contract.
and purchaser arrangement.
Yes.
Yeah.
A contract. And Mr. Justice Bannister put it to Mr. Hockhauser that there was no consideration given for this alleged promise. We didn't argue that, and we wouldn't. We don't argue it now because if there was such an agreement were approved, the consideration would be, in consideration for you investing this property in me for 6 months, I promised to return it back after 6 months. So there isn't a consideration problem.
Yes, perfectly.
But what I wanted to do before your lordships
Sorry, I was interrupting. Yeah.
is to show your lordships the very important post-trial written submissions which were initiated by Mr. Hockhauser, who clearly wanted to get in writing what he had intended to say in closing.
Right.
Now, these are, I hope it's not unhelpful, they're not with these closing submissions in the bundle because
Where are they? Where are they?
they've been put later.
Are they in this thin bundle?
They're in bundle, no. They're in bundle 9.
Thank you.
The way it's been done is the
Well, it doesn't matter why it's been done that way. They're in bundle 9.
bundle 9,
Yep.
tabs 3 and 4.
That's very helpful. Thank you. Yep.
It's straight after the transcript of...
Page 1639. Yep.
That's right.
Which paragraph do we look at?
Well, now, my lord, I don't want it to appear I'm doing this unfairly. Would your lordships look at 1639?
We are.
This was sent to the judge by Mr. Hockhauser the day after the trial had concluded.
Right.
And paragraph 1 begins, this short further written submission summarizes those parts of the submissions that were made orally only in answer to the judge's question.
Okay.
It's hoped it will be of assistance.
Yeah, okay.
I'm not going to look any more at this document because the way we responded, we put this written response in the following day, tab 4, 1641.
Well, I see your point in paragraph
What we did
1.
is we set out, even to the extent of using the same font, we set out each of Mr. Hockhauser's paragraphs.
Which paragraph do you want us to look at?
And then our comments follow.
Yes, which paragraph do you want us to look at?
It's the first sentence.
Paragraph 2.
First sentence, ignoring the two separate estoppels.
Yes. Paragraph 2, this ignores the two separate estoppels, etc.
Yes.
And then we deal with his point about Air Jamaica, paragraph 3.
Yeah, where else do you want us to
Then
look?
4, central question is indeed why did the transfer take place, but story is wholly implausible, etc., etc. Documentation doesn't reflect the true understanding of the parties, they say. We say this allegation doesn't reflect the loving and trusting relationship which existed. Specifically, it wasn't consistent with their de facto marriage, and it's perhaps interesting to pick that up because I don't think it's referred to anywhere else, including our written cases. Actually pleaded in the amended statement of claim that there was a de facto marriage, though in his witness statement he denied that. And then 6 is important. He said the documentation doesn't reflect the true position. We said the fact that a consideration of 40,000 was stated in the bought and sold amounts in the transfer is consistent with an intention to pass the beneficial interest. And that's a fortiori when no money actually passes hands, but the parties are in a loving and trusting relationship as de facto husband and wife. Go back to Meraki.
Yeah, very well.
That is why in Meraki there was the consideration was never paid by Mrs. Meraki's company to Mr. Meraki. She said, there was no evidence from him, but she said they'd always intended the apartment to be hers. It was purchased before they were married, but she became pregnant shortly afterwards, and they were then married, and it was intended to be hers. There's nothing surprising about a transfer outright, legal and beneficial interest, for whatever reason,
Yes.
as between two parties in that relationship.
Yes.
And then Lord, we rely on, they say if the court finds the true understanding was she was to hold the legal interest only for 6 months, she fails to shift the burden of proof, etc. And we say all the evidence is actually against that.
Yes.
And then 10, the plea of estoppel in these circumstances cannot succeed, and at this stage he does refer to para 9Q and R.
Yes.
And he refers to his reply, the pleaded reply to those paragraphs, which simply says Mr. Didn't have the understanding of the legal consequences of the document signed, which of course is completely irrelevant. And then we say, on the contrary, she clearly relied on the transfer, showed she didn't believe she was under any obligation to retransfer when she wrote to the bank, 3rd of July, obtained a provisional order for possession of the hotel, etc., etc.
Doesn't clearly relied on the transfer postulate, though, that she wasn't aware that Mr. Nung was giving it her for the purpose of a temporary purpose or for a purpose which didn't involve the transfer of the beneficial interest? I mean, she can't rely on the documentation to say she has a beneficial interest if she's actually aware
She doesn't.
that she's not been given it. So,
Well, that goes back to the whether the judge was entitled to reject the Kutai Strip project story. I mean, her evidence, she was cross-examined.
or to reject the story completely that Mr. Nung, for whatever reason, wasn't transferring the beneficial interest.
Yes, exactly.
But
I mean,
all this
her evidence was that she had nothing to do with the Kutai Strip project, and the transfer was nothing to do with it.
Yes, absolutely.
Her evidence was that she became worried after the very prominent
Yes, after the bad publicity, and asked for the
Ponzi scheme,
legal transfer to be transferred to her.
and
Yes.
effectively
But
she
that
said,
wasn't
to
believed
him,
either.
Look,
But that wasn't believed.
you know,
Lord Hodge had a question.
with publicity like this,
Well, but she wasn't believed. Lord Hodge had a question.
so sorry.
No, not at all. It's simply that you're responding to their assertion in 10 that the plea of estoppel at 9Q can't succeed.
Yeah.
And you enter into the question of reliance. But as you present it today, you don't need to get there at all. You don't need reliance because it's a contractual bar. So in a sense, your answer is beside the point. But what it does show is that the claimant was well aware that you pleaded a 9Q estoppel.
By the time of these post-trial submissions, Mr. Hockhauser had probably, after apologising on day 6, he'd gone back and looked at it again and found the plea. So
this contractual estoppel, which the board has established in the prime site case, it can mean, can it, that if you enter into a document which says, I'm transferring the beneficial interest to you, then even though that's not intended, and both parties know it's not intended, nonetheless there's an estoppel. Is that right?
absolutely.
You can have a rectification.
Absolutely. Don't forget, my lord, Mrs. Meraki's case was.
Why isn't it the end of, it's the end of all sham arguments, isn't it? You would never be able to say that the document doesn't mean what it says, because you'd be stopped. If you enter into a sham document, you're stopped.
Well, if
Well,
you
in
went
Snoop,
into a sham document, that would be on the footing
Yes.
that none of the statements in it was intended to be taken seriously.
But why doesn't that apply to
Snook,
particular
it was.
statements? Why? I mean, here, the whole essence of the document is said to be that beneficial interest is transferred. If you deny that, you're saying the document's a sham. So effectively, you're undermining the whole document. But you say you're stopped from doing that. I mean, this is a rather radical change to the law.
We may have to look at Snook after the short adjournment, because if your lordships remember, in Snook, Lord Justice Diplock and Lord Justice Russell disagreed with Lord Denning.
I don't remember.
They didn't.
Well, they did.
They didn't. Lord Denning thought it was a sham with the consequences.
It would be a sham here if the reality was that the parties did not intend to contract on the basis as if the consideration had been paid.
But basically all was being said was,
Yes,
this is what we're charging, but the claimant, the recipient, the vendor, is happy to waive his right to receive it. That's all. Nothing particularly
We
startling.
contract that we will deal with each other on the footing that
yeah.
they have received
It was
it. Now,
put-
if that was a sham, then you wouldn't go down that way, but it hasn't been established. I think your submission is that it was. Indeed, that was contrary to both.
But if both
We'll
parties
see.
are happy to proceed on that basis, then it's not a sham.
Well, yeah.
It wasn't done for deceiving anybody or dishonestly. They were just happy not to let the money pass, but that doesn't make it a sham.
Lord, the waiver analysis was advanced on behalf of Mrs. Meraki in prime side and was rejected by the board. So we'd better look at that too.
Well, yeah, but quite how you analyse it doesn't matter. Clearly, it's open to the parties to agree that the money is treated as received, even if it hasn't been.
Yes.
That's the point.
But just as whet your lordship's appetite about Snook, we'll find if we look at Snook that estoppel is dealt with by Lord Justice Diplock and Lord Justice Russell. So may I refer you, lordships, to that after the short adjournment?
Yes, very well. We'll resume again at 2 o'clock. Court's now adjourned. Thank you.